So good morning, everyone, and good evening to you, Michael Kirby. I'm delighted to welcome everyone to the University Philosophical Society today. On behalf of the Society and our senior patron, Dr. Provost, Dr. Patrick Prendergast, thank you all for joining us today to welcome the latest recipient of the Gold Medal of Honorary Patronage, the Honourable Mr. Michael Kirby. Every year, the Council and members of the University Philosophical Society elect a select number of exceptional individuals to the honour of honorary patronage in recognition of their outstanding and significant contribution to their given fields. We're absolutely delighted to recognise Mr. Kirby's work here today. Michael Kirby was first called to the New South Wales Bar in 1967, and by 1975, he was the youngest man appointed to federal judicial office. He then went on to serve as president of the New South Wales Court of Appeal before being appointed to the High Court of Australia. On that court, he was described as a legal progressive who was defiantly internationalist and sought to move forward the legal debate surrounding human rights, as he became known for dissenting with his more conservative colleagues. He's been active extrajudicially, working with the World Health Organization to support people living with HIV and AIDS, advocating for equality for the LGBT community, Indigenous peoples, women, and religious and ethnic minorities, and leading a commission of inquiry into human rights abuses in North Korea for the UN. It is our honour to grant him honorary patronage to the Society today. But before we ask a few questions, I understand you'd like to say a few words.
Well, I certainly would, and I'd like to express my sincere thanks to the Philosophical Society of Trinity College Dublin. It's a great honour for me, especially because all of my family came from Ireland. Some members from Northern Ireland, that's on my mother's side, and some from the Republic, and that was on my father's side. So I'm really an Irishman, and I want to get my medal. You haven't sent the medal. Maybe this is a trial run to see whether I really deserve the medal. But I want to get my grubby hands on the medal and to feel this link with Trinity College Dublin. Actually, you know, I had a little operative procedure in St. Vincent's Hospital in Sydney, and the nursing sister in charge of anaesthetics was named Karen, and I told her I was coming to this, and she said that she is a graduate of Trinity College Dublin. And so Trinity College is everywhere, and it's out here in Sydney and working in St. Vincent's Hospital with us in Australia. We're all together, and there are certainly a lot of links with Australia. One of the things that I've been engaged in the last few months is to build a history of my time in student politics. And this has been encouraged by Julia Gillard, who is one of my predecessors in this honorary patronage. She was Prime Minister of Australia and was a very wonderful leader and our first and so far only woman Prime Minister. So we're trying to build this record of the time when we were in student politics, and Julia's going to contribute and I'm going to contribute. And looking back on those days, you realise how much there was to do and how much was achieved, but how much there remains to be achieved. Back in those times, it was even more grim for Aboriginal Australians than it is today. And you know, there was a principle of law which had been upheld in the courts that Aboriginals could not have legal protection for their land rights. And I never put my hand up in the classroom and asked, please, sir, why do we not recognise the land rights of the first people of the country? And that really teaches how important it is to be a questioner and to ask questions. But as well as that, back in our time in student politics, we had white Australia in Australia, and we had a principle in migration that it was virtually impossible for people who were not of Caucasian background to get into the country. Even if they were married, they were not allowed to come. And all of that really derived from a feeling of fear and hatred of people of a different appearance. And so that was a very strict rule, and it was only overturned in the end, not by our parliament, which is one of the longest established parliaments in the world, but by the courts and the decision of the High Court of Australia. Women's rights were unequal, and women's rights in the common law were unequal. And again, I never put my hand up and said, please, why does a woman have to take her domicile for divorce proceedings from the domicile of her husband? Why doesn't she have her own domicile? Or in a married relationship where there are often children who are with the woman, why would you not take the woman's domicile rather than the man's domicile? And I never really questioned all of these assumptions. But the one issue on which nobody was raising any voices back in those times was lesbian, gay, bisexual, transgender, intersex and otherwise queer Australians. We never really asked the question. That was a forbidden topic. And so looking back on those times, it really teaches me how unquestioning we were and how important it is for the Philosophical Society at Trinity College, Dublin, to be emphasising the duty, responsibility and the privilege of educated people to be questioners and to stretch their mind so that they ask, well, what are the things that we are not seeing today which we ought to be questioning and putting before our community? And I think that's the challenge, because if you're not questioning things, then they tend not to get raised in public debate. So today, you know, is Mahatma Gandhi's birthday, and therefore it's his sesquicentenary, 150 years of Mahatma Gandhi. And so it's a great day to have this ceremony. I believe you when you tell me that the medal is in the post. Like my check, the medal is in the mail, and I'm waiting for it to arrive, and I will place it on display in my chambers in Sydney and be very proud of this additional link with Trinity College Dublin.
Thank you so much. It's something it's really interesting to hear you speak about student politics and the importance to kind of question the things that are going on in the world. And I suppose in light of that, I'd kind of want to ask you something about something that's creating big waves in the sort of legal and international community, that being the death of Ruth Bader Ginsburg, and someone that you have a lot in common with. Obviously, you both come from minority backgrounds that weren't traditionally represented in courts and earned a reputation for dissenting, and on a lighter note, both granted honorary patronage of this society. But the rule of law in the United States and around the world is in a moment of crisis with everything that's going on with Donald Trump and his attempts to evade legal accountability. And many are particularly worried that he's going to try and stack a court where there's not much diversity of opinion. And as someone who's always defended minority rights, even when it wasn't popular to do so, does the idea of a stacked court worry you? And how do you feel about the state of rule of law in the United States?
Well, you see, you've got to answer a question like that by reference to the actual text of the Constitution of the United States. And it occurs to me that what was objectionable was not so much the fact that the president, exercising powers which are given to him by the Constitution of the United States, should take advantage of the vacancy that's created by the death of Ruth Bader Ginsburg to place before the Senate for advice and consent, as the Constitution envisages. None of that is really, to me, particularly surprising. Of course, a Constitution has principles and conventions that grow up around the words. And I understand that in the United States, on a number of occasions where a death has occurred or resignation has occurred of a justice, then a president facing election will say, I think this should be left to the new administration and the new president. But that doesn't always happen in the United States, and it's not terribly offensive to me to see a person who has the powers of the president and who will have those powers, whatever happens in the election, until the handover, which is the third week of January. What was offensive was the fact that President Obama, in quite an early phase of his last year in office, nominated a person who was a very distinguished and able and talented and not especially political judge, and the party, the Republican Party in the Senate, wouldn't even bring that proposal from the president to the floor of the Senate. So that was really where things came unstuck, and that was really the wrong thing. I don't think the fact that Ruth Ginsburg prayed or wanted that it go over to the next term. I mean, that's not the way constitutions work. Presidents operate and decisions are made. What was really objectionable was that a sitting president who had not reached the end of his term nominated somebody and they wouldn't even put it up for discussion. And that was really a breach of convention. And that is why a lot of people feel, well, you said then, let's leave it to the next president, and you're not doing that now. So there's a bit of hypocrisy. But is that the first time you've seen a bit of hypocrisy amongst politicians? I don't think so. Can I just say, I really loved Ruth Ginsburg. I knew her well. I went with her to a conference in Bangalore in India in 1988. We helped to develop the Bangalore principles on the domestic application of international human rights norms. Those principles, which were signed on by all the judges who were there, chaired by the Chief Justice of India, those principles have been very influential in our judicial lives, and they remain influential in my life as beckoning us to a world in which international law can be of guidance and help to domestic law.
Absolutely. I think on the subject of law, I suppose, in a more broad sense, obviously laws around the world are changing very rapidly and generally uniformly to try and attempt to curb the spread of COVID. And more people everywhere are paying more attention to the process of legislation, which is obviously good for people who have a vested interest in the law like ourselves. But there is obviously, in most countries around the world now, at this stage, 7 months in, we've seen a lot of political and legal scandals where powerful people have been seen not following the rules for everybody else, and obviously undermining people's faith in the legislature and the judiciary around the world. And do you think that the COVID-19 crisis has undermined international faith in rule of law, or do you think there's hope? Like, what do you think can be done by the international legal community to restore faith in our institutions in this moment of crisis?
It's going to be really difficult for us all to get back to the real world because COVID has had such a big impact. I'm sure it would be the same in Ireland as it is in Australia. Every court, the highest court in the country, down to the local magistrates court, have introduced distance of communication, being able to beam the hearings from people's homes or from offices in the suburbs, avoiding congregating in courts. All of this is fairly standard. And you know, for years before COVID came along, when I moved from the Court of Appeal of New South Wales to the High Court of Australia in 1996, one of the biggest changes I noticed was we did special leave applications. And Australia is a continental-sized country, and therefore I would have to sit in the number 2 court and they would beam in the barristers from Perth or Darwin or Hobart to Canberra. And it was actually amazing to me because we didn't have to do that in the New South Wales court. But in the High Court for the whole country, we had this system of speaking to counsel in the far reaches of the continental country. And therefore you get used to it. And it's really very surprising how the human brain can adjust so easily to the fact that you're talking to a screen and there are the people and there are the parties and the lawyers in their wigs and so on, thousands of miles away in the case of Australia. So That's not new. What is new is what will follow from that. First of all, the question of whether Parliament has delegated too much power to the executive government, whether provisions have been made sufficiently for the legislature, which is the representative of all the people, to take control and keep an eye on liberties and the rights of all people, and the scrutiny of officials, because officials always want to have more and more power, and it's therefore very important that be under the scrutiny of the legislature and of the scrutiny of the people. One of the problems with courts online has been getting access for the public to see judicial proceedings. The parties can do it by having the link, just as we have this link now, but how can the general community get access? And I was interested today to see a note that the Land and Environment Court of New South Wales, which is a court that specialises in land disputes, has introduced a system to simplify and increase the access of the public to court proceedings. So this aspect of it is being considered. It's very important that we protect ourselves from contact with the virus, and that was really brought out today by the report that President Trump and his wife are themselves testing positive to COVID-19. But it's also very important that everything should, as far as possible, be able to be scrutinised by members of the public. And one of the issues in Australia that we're talking about is the extent to which our change, our revolutionary change in respect of the COVID-19 video links, whether that is going to lead on to the automatic decision-making, so that we provide for algorithms to be studied and for decisions which can be provided by automatic process, or whether you've got to ensure, for the protection of human rights and human dignity, that a human being is interposed who will judge whether or not the decision which is coughed up by the machines is a decision which respects human rights, and human rights, particularly minorities. There is no way that a machine would have provided in Australia the decision in the Mabo case, which was a very important case in Australia that reversed 150 years of land law and said that the indigenous people do have a right to access and protection of their land rights. That would not have been done by a machine. That required human beings, judges who felt that the old common law principle was not suitable to the age of universal human rights, that it was discriminatory on the basis of race and indigenous status, and that it had to be changed, and change it was.
Absolutely. I think you're definitely right in saying that there's just no replacement for kind of human empathy, and there's no way you can program human empathy. Do you think there's been more of a renewed interest in human rights in light of this crisis, which is obviously could sort of heighten the sort of division and kind of systemic inequality that exists in the world already?
Well, inequality exists, and to the extent that, say, for example, people who are floating on a little boat to Australia to gain access to our refugee entitlements and to assert that they are refugees with a well-founded fear of persecution. In some cases in Australia, we have sent people in that situation to offshore islands. And I received an email today saying that a similar sort of arrangement is under consideration in the United Kingdom at the moment. I think that's a precedent from Australia they could do well not to copy. because it cannot be consistent with the Refugees Convention, which the United Kingdom, Ireland and Australia have all signed, that people who are coming to you in a particular way, namely by a ship, have got to be treated differently, have been intercepted and sent off to Nauru or to Papua New Guinea, Manus Island, or to some other offshore place. We have committed that we will, in those circumstances, provide them with an opportunity to demonstrate that they are entitled to refugee status. And when you promise that, that is what you have to do. And until the Refugees Convention is changed, that is what countries which signed up to the Refugees Convention agreed to do. And we did that because of our reaction to the horrors that were revealed after the Second World War of the treatment of refugees in that circumstance, and our promise to each other and to the international community that we would not deal in that way with people who had a well-founded fear of persecution.
Absolutely. I think on that right to health and safety, this is something that across the world most LGBT people don't have access to, and in many countries they have almost no rights at all and live in a lot of secrecy and fear. Obviously courts across the world and across history have been responsible for a great deal of pain inflicted on LGBT people. But equally, courts in India and the United States in recent times have been able to recognise the innate human rights and dignity owed to the LGBT community and have been able to advance equality. As you say yourself, obviously the law can be an oppressive and a liberating force, or a hindrance, and also an opportunity. I wonder, as the first openly gay High Court judge of Australia, you've obviously had an unprecedented experience being openly gay in a place where this wasn't historically encouraged. And I'm wondering, what was that experience like for you? And more broadly, what are your hopes for the next generation of LGBT lawyers and judges who seek to transform the law into a more liberating force for themselves and for other people?
Well, I'd like to start the answer to that question by paying a tribute to David Norris, Senator David Norris, and to Mary Robinson, who was his counsel, and to other judges in Ireland, and to Neil McCarthy, who I remember from the Bangalore meetings which we had talking about the domestic application of international human rights law. It really requires people to stand up, and I was not only the only or the first Australian High Court judge who was open about his sexuality. I wasn't certainly the first High Court gay judge, but I was the first who was open about it. But my understanding was that I was the first judge of a final court in the whole world who was ever open about their sexuality. I mean, it's a bizarre thing to think about, and that lasted so long demonstrates how powerful was the imagery that was really forced upon LGBT people to deny themselves and to be invisible. That was the objective. Because you were told that you were so shocking and abominable to people, the deal that was struck was that you would be silent about yourself, and indeed you would be misleading about yourself, and you would be disguising the reality of your own life. And I was sort of totting along and going along with this, but my partner is from the Netherlands. And you may know they're very difficult people. The people of the Netherlands are extremely difficult. And he said at one stage, how long do you think you're going to be living? And I said, well, my father lived to 95. And he said, we've got to stand up. And I said, well, don't you think it would be more correct to leave it until after we've left the court? And he said, definitely not. We've got to do it, and we've got to do it now, and we've got to do it for the young people. And I think that's true. Until people started to shatter this plot, this deal that was done, it was never going to change. So we did help to change it. And I think that was actually quite good for the other judges in the court. They probably all gossiped anyway about me, My partner kept a low profile at that stage, but it's in a sense the way we overcame our fear and hatred of Asian people in Australia. The reason behind the White Australia policy was the same. Make sure there aren't too many of them. Make sure that they hide themselves. Don't confront us with their reality. And all of this has to change if we're to secure fundamental human rights, and a realization that it's actually very good in societies that have diversity, societies that respect difference and diversity are generally very rich in culture, in music, in poetry, and art, and suppressing these things is really an unnatural situation. If ever the crimes that used to be in the Crimes Act of New South Wales when I was a young law student, unnatural offences. Well, what was unnatural was being told you had to hide yourself and be ashamed of yourself and keep it all quiet. Don't even mention it to your parents. Never talk about that to your parents. It'll upset them far too much. Keep it very quiet. And all of that is beginning to crumble. But it hasn't crumbled in some countries, where there are still very strong religious and not necessarily Christian religious viewpoints. It's often very difficult to get things changed. But what we mustn't be just content with our situation in Ireland or in Europe or in Australia. We've got to be concerned about the situation in Indonesia or the situation in Malawi or the situation in Guyana or in Trinidad and Tobago and in other parts of the world, and in Russia and in Eastern Europe.
I think that if clearly have a kind of great understanding and appreciation for human rights, and that appreciation isn't tied to any one jurisdiction, that it should be everywhere and unconditionally. I'd love to ask you specifically about North Korea, where we obviously know that those laws are quite brutal and human rights tend to be quite weak. What was the most shocking thing you learned in your investigation into human rights in North Korea, and what are your hopes for progress and improvement in that area?
Well, I suppose the most striking thing was sitting there in hearings. You see, normally the UN conducts inquiries in the European tradition. It conducts them by the inquisitorial system. It doesn't conduct them in public. It doesn't film them and put them online as we did. We did it in the Anglo-Irish, American, Australian common law tradition, and we did it up front. And that's why our report created a sensation when it was delivered to the UN, because we demonstrated when North Korea said, all of this is lies, these are people who hated their country, we say, go online, have a look at it and make up your own mind if it's all lies or if what is being said is truthful, as we believed overwhelmingly it was. So sitting there as a former judge and hearing the testimony of a woman who was forced because she moved from China back into North Korea and had delivered a baby in the custody of the North Korean border guards. She was required to drown the baby. And hearing stories of that kind, hearing of the people who had to collect the bodies in the prison camps and put them on a wheelbarrow and carry them to the incinerator in order that they be burned. It struck me that what I was doing was not all that dissimilar to what happened in the Nuremberg trials, that these were monstrous and horrible stories. And as a result of the Nuremberg trials, the crimes against humanity and the crime of genocide and the international war crimes were developed. And we promised that we would do better in the future. We would not turn our back to crimes that shock the conscience of humanity. And the problem has been that it has to be said, since the Trump administration began in the United States, that really the pressure on North Korea from the point of view of human rights has gone off the boil. And President Trump has never mentioned the human rights situation in North Korea. He has focused on nuclear weapons, and there's no doubt that that is a very major problem and a major human rights problem. But you can't have peace and security on the Korean Peninsula when you have monstrous crimes that are being committed of the kind that are recorded in the report of the Commission of Inquiry and that can still be obtained on the internet by simply Googling the Commission of Inquiry and going to collect that information. It's still there, and it is a reproach to the government and leader of North Korea, and it's also a reproach to ourselves that we've simply gone quiet on this. And sadly, the government of South Korea has gone quiet on this, and we must lift our voices against these crimes, just as ultimately we did at Nuremberg and Tokyo after the Second World War.
Absolutely. I think you mentioned the Trump administration there, and obviously he has made it more difficult for the international community to hold each other to account by simply refusing to play ball and setting a dangerous example for other states across the world, obviously voting poorly for the future of multilateralism. Do you think this could be reversed, or will the US have to work to rebuild its reputation across the world, even if Trump doesn't win re-election in November?
I found working with the very clever people in the State Department of the United States when I was chair of the Commission of Inquiry and in the follow-up to the Commission of Inquiry, I really came to respect the high intelligence, the great experience and the strategic sense of these career diplomats who served the United States. I mean, these are the people who are in the line of Eleanor Roosevelt and those who built the international human rights movement. We've simply got to restore that. Washington is not just a swamp. When I was a little boy in Sydney during the Second World War, Eleanor Roosevelt came out to Australia. She came out for the president in order to give messages of encouragement to American troops and also to Australian and New Zealand soldiers, and to open a big hospital which was near the home where I grew up in Sydney. And she came along the road outside my school, and I was sitting in the gutter, and her car and motorcade went by, and I was waving a flag, and I swear that she looked right at me. And my teacher, who had fought in the Second World War, after the war, gave all the children a copy of the Universal Declaration of Human Rights. And we were taught about the Universal Declaration of Human Rights. And it wouldn't be a bad thing if children at school in Ireland and in Australia and in other countries and in the United States were taught about these principles, because my teacher, Mr. Gorringe, who'd fought in the war and saw how dreadful war was, said, unless we can observe these principles of the Universal Declaration, we are going to go on killing each other. And now with the nuclear bombs, that will be even more devastating than it has been in the past. So I think there's a lot to be learned, and the Americans really played a very great role in building that. And my hope is that one way or the other, either under a second Trump term or under Mr. Biden, that we will go back to using these very intelligent people to hold truth to power and to make the regime in North Korea accountable to the world for the terrible crimes against humanity that are revealed in the report of the Commission of Inquiry on North Korea.
Absolutely. I wonder, in light of all of this and in light of those hopes for the future, What do you think is the most important issue facing judiciaries around the world now, and what issues do you wish judges, lawyers and law students would spend more time considering?
Well, this comes back to the thing I was saying in my introductory words. It's impossible to be sure what the issues are going to be in the future, because I didn't see the issues which are so blindingly clear today when I was a very intelligent young law student and very much involved in student politics. I'd led a delegation to Nigeria and Ghana and to Malaya and Singapore. And it was actually when I did that, when I got out of my own little cocoon and started to see the world and started to get challenged. I mean, when I went to Nigeria, I was challenged about Australia's treatment of the Aboriginal people and about the white Australia policy. And I stumbled and tried to answer why we had these policies. Well, we have our own culture and we have our own history and we want to keep our own country in our own way. But that was very unsettling for me. And that's why it's very important to have bodies like the Philosophical Society with contrarians, with people like Oscar Wilde who will really challenge and students who will stretch their mind. You've really got to focus on what am I not seeing? And there are things that I am not seeing now. For example, animal welfare rights. I mentioned that this is Gandhi's sesquicentenary. He was very strong on cutting down on meat, cutting down on the slaughter of animals. It really is very surprising looking back as somebody who was brought up in a Christian belief that so much attention was given to what human beings did as consenting adults in private in a bedroom, and yet very little was done about the abject cruelty of the slaughter of animals. And nobody really questioned it. The animals were things that were put on earth for our entertainment or our pleasure. And now I think animal welfare is going to be a big issue. Obviously, climate change is going to be a big issue. Poverty, grinding poverty of about 1/3 of humanity is going to be a big issue. And above all, nuclear weapons is going to be a big issue. I really have to give full marks to Ireland because Ireland voted recently for the ban treaty. This is the treaty to ban the possession and use or threat of use of nuclear weapons. My own country, Australia, says, no, we want to be under the protection of the American umbrella, as it's called. But Ireland said, unless somebody does something, sure as night follows day, we are going to have an accident, or we're going to have a mistake, or we're going to have somebody lose their temper and do something really violent. And I think that's why Ireland's ratification of the ban treaty was a very good thing. And I wish the government in my own country, Australia, would do a similar thing. New Zealand, feisty little New Zealand has ratified, and feisty Ireland has ratified. We need a bit more feistiness in the world, but that comes from educated people raising their voices and stretching their minds and seeing the challenges which have not been seen heretofore.
Absolutely. And on that, about sort of student leaders and people being willing to stretch their minds and be a bit feisty and stand up for things, obviously your career in student politics shaped your view of the world, and I wonder what advice you'd have for current student leaders and people who are in those roles now.
Well, I think giving advice is one of the privileges of old age, and I think it's really the only advice I can give is to really think outside the square and not to be boring. It's very easy to be boring in this world and to be absorbed with making money or making fame and so on, but the fundamental problem with our legal system, if you're starting in your own little environment of the law, the fundamental problem is that it is so expensive that most people can't get to it. If you ask judges in Australia, would you ever go to court knowing what you do about the legal system, they will normally say that that is an unusual form of punishment. I would never do that. It's just too expensive. And therefore, finding a way to get access to justice for ordinary folks, that's a very important challenge in the law. And I think this is something which we all have to be concerned about. There was a conference in Hobart in the 1990s, and it was about access to justice. And a German judge, Dr. Zeidler of the Verfassungsgerichtshof, came and he said, in Australia, you have a Rolls-Royce system of justice. In Germany, we've just got a Volkswagen system of justice. And everybody sat up in their seats and thought, oh, isn't that wonderful? We've got the Rolls-Royce. And he said, but how many people can afford a Rolls-Royce? And how many people can afford a Volkswagen? And I think that's a real question that in Ireland and in the UK and in Australia and in New Zealand and in America and in Canada, we've got the Rolls-Royce system, but it's just so expensive, and we've got to find ways that can serve the cause of justice for ordinary people, and that is our biggest challenge as lawyers. But our biggest challenge in humanity is saving the species, saving the planet, saving animal life, saving women's rights and protecting women against neglect by the patriarchy, protecting LGBTIQ people, protecting refugees, protecting prisoners, protecting the vulnerable, the poor. And if that's not enough, then I'll come back for another medal and I'll give you another list and more suggestions. But the real suggestions will come out of your mind and out of your experience and out of your engagement with the new technology and with the new opportunities that the technology produces for access to justice for all people, not just in courts, but in ordinary lives and in the world, and especially the nuclear world and the world of climate change and of pandemics.
You mentioned there actually touches on a question that we've just gotten in for some students. So I'm going to open the questions up to students. The student writes in saying, having seen the Black Lives Matter protests build over, how effective do you think protests are in changing systemic racism? How would they compare to students across the court?
Well, I think the Black Lives Matter is certainly it's a matter that is of relevance to us in Australia, as I've tried to show, because of our neglect of the indigenous people, our belief, which was factually and anthropologically incorrect, that they were very few and just nomads and uncivilized people. We didn't really have to worry about them. So much so that there was a provision in the Australian Constitution as it was originally drafted that said that they were not to be counted in the census. And the excuse for that was, oh, well, they're wandering around the middle and we just don't have anything to do with them. We just forget about them. And that was removed in 1967. But that is what people put into the written Constitution of Australia. And they also put in there a provision which effectively prohibited the federal parliament from doing anything to improve the situation. So in Australia, we need to be reminded that Black lives matter and brown lives matter and white lives matter, and not to be content just with phrases or with invocations or with celebrity, but to try to make better policies, better laws and better education. I think Black Lives Matter is in its most acute form, bound up with the American experience with slavery. And though we all in Ireland and in Australia and in New Zealand and other countries, we have had very great injustices, we really adopted, as from the beginning of the 19th century, back in 1820, 1830, a prohibition on slavery, and no slave could enter into our countries. And but once they breathed our free air, as it was said, they had their political freedom. But in America, that wasn't so, and they had to fight a civil war about that. And I think they're still coming to terms with the cultural and other crises that the slavery experience has left as an indelible stain in the United States, especially.
Absolutely. And we've two more sort of questions I'd love to read you. One is from Megan O'Driscoll, and she says, given your record of standing up for the rights of oppressed groups, specifically Indigenous peoples, and growing concerns about climate change, what do you think about Australia's use of secret courts for the trials of whistleblower witness Kay and his lawyer, who exposed Australia's abuse of power and espionage during oil and gas negotiations, and the use of secret courts in general?
Well, I'm not in favour of secret courts. I was a judge for 34 years, and from time to time, I had applications by lawyers to close the court. And once I even saw a court officer who'd been persuaded by one of the parties to close the door of the court. And I said, "Officer, open that door." It's a very important principle of our system that our courts sit in public. And the theory of that is the way that the ordinary people can judge the judges as they were performing their duties. That's in a sense why in the Commission of Inquiry on North Korea, we invited the media in, we invited cameras in. If it was safe to the witnesses and they agreed, we invited them to give their testimony online and speak truth to power so that testimony would be before the community. These are the reasons for openness. Of course, one of the problems is you can have an open court, but the judge can make orders that no reference may be made to the testimony in the court. And if that's backed up by statutory provisions, as often is the case, that will have a dampening effect or a chilling effect on the proceedings and on the information that goes to the public. It is true that in the struggle against terrorism, we've always got to be careful that in struggling against terrorists, we don't embrace the terrorism of those whom we are trying to overcome. There are very violent and cruel people who use terrorist means, but it's really amazing to me, as somebody who was the chair of the Australian Law Reform Commission when it was first set up, how hard we had to struggle to get even very technical and really basically very uninteresting law reforms enacted, and yet how on terrorism, without any opposition from the opposition parties, the governments can get a whole raft of measures. Australia has enacted hundreds, if not thousands of measures in the protection against terrorism. And sometimes you've got to remember the principle of proportionality, which is a very good principle that we've learned from the Germans. It's in the German constitutional jurisprudence. And I think proportionality is important so that you do not create a network of laws that is excessive and disproportional to the problem against which those laws are addressed.
Absolutely. We have one more message from a student, and then I'll ask you one more question we can finish up. This is a very nice message from Annie Wall, who writes, "Not a question as such, but it's a huge privilege to be able to attend an address by a judge I've grown to admire and revere so much throughout the course of my degree. One of the only silver linings of this pandemic is we now have the opportunity to connect with people who are so far away. Thank you so much for sharing so much wisdom and insight with us today, and you're a massive inspiration to many." Which is a lovely message.
Well, that is a lovely message. My partner, when he hears a message like that, says, he's not inspiration, he's perspiration. All he's done is work very hard. And I think if I had advice to lawyers, I would say, wow them with your hard work. Because that, to be truthful, after 34 years as a judge and years before that as a solicitor and a barrister, the truth of the matter is that the people who win cases are those who get in there at 4:30 in the morning and are working flat out to get all of the details into their heads so that nobody can trip them up and nobody can overcome their knowledge of the facts or of the law. And that is what clients expect of us, and we have to fulfill that expectation.
Absolutely. You actually even answered the question I was going to ask about what your advice would be to lawyers. And it's obviously it's not so much about inspiration, it's not so much about luck, although those things can play a role. It obviously is more so about working really hard and being willing to stretch your mind in different directions.
Well, that is what I would say on this sesquicentenary of the great Mahatma Gandhi. He spoke long before others did about animal rights, about women's rights, about climate change, and about even sexual rights and sexuality. And he was a man who really stretched his mind and said, as we all know, be the change you want to see in the world. So by our lives, we have to be a good illustration to one another of goodness and kindness, and not formalism. It's always the weakness of the law that it slips into doing the formalistic without asking, well, what is this rule for? And is this still applicable in the modern age? And in the Mabo decision, before I was on the High Court, a very great Irish Australian, Justice Gerard Brennan, he stretched his mind and stretched the principles of the common law, and he carried six judges with him, that is to say 5 others. 1 judge dissented, and that is our system. People express their honest and sincere views. And I pay a tribute to Ruth Bader Ginsburg. She was a wonderful friend of mine. I once said to her, I've got this very bright young associate, we call him, clerk, and he's in the United States, and he would love to come and spend a day in your chambers. Now, there were American law students who would have killed for that opportunity, but this clerk, whose name was Niranjan Arasaratnam, he was a young Australian of Sri Lankan origin, and she said, of course. And so he spent a couple of days in her chambers. She was a generous spirit, and she was a great champion, not only of women's rights, but also of LGBT rights, because LGBT learned from the struggle for women's rights. And I mourn her passing, but she has left a legacy for us all, not just in the United States, also in Ireland and Australia.
Absolutely. I'm really struck there by something that you said about letting our lives be an example to others in light of Mahatma Gandhi and in light of Ruth Bader Ginsburg. And I think your life will be an example to many people, particularly in the LGBT community and in the international legal community. And in light of that, that's why we were so glad to have you here today and to give you the honorary patronage, which I'm very excited for you to receive your medal. And if not, we can have you, we'll send you over to Dublin and give you a second one. But thank you so much for taking the time to speak to us today, and for everything that you've done and continue to do for minority rights around the world. So thank you so much. It's been an honour speaking to you today.
Thank you very much, Kate. And thank you for having me. And I hope I can come to Trinity College, Dublin, and meet you all in person when this horrible experience has passed.
We'd love to have that. Mind yourself in the meantime, in the midst of this, the rest of this horrible experience. Hopefully it'll be over soon. So see you soon. Thank you so much.
Thank you, Kate.